I had $1 million,
If I had $1 million,
well, I'd buy you a house.
I would buy you a house.
And if I had $1 million,
If I had $1 million,
buy you furniture for your house.
maybe a nice Chesterfield or an ottoman.
And if I had $1 million,
If I had $1 million,
well, I'd buy you a K car.
a nice Reliant automobile.
And if I had $1 million, I'd buy your love. If I had $1 million,
I'd build a tree fort in our yard.
if I had $1 million.
Hello, this is Lynn Chase, and I am recording my thoughts about the final project for my Opal course in e-learning principles and practices. Now, the final project is supposed to be a sort of an e-learning module, and what I am considering doing is to create something regarding the Americans with Disability accommodations requests and the training that I have discovered needs to be done, because most colleges and universities are not following either federal or state law. So that is my focus. It may be a little too much for this first project, but that's my hope is to cover these 4 topics. And I think that each will be about a 15-minute lesson. The first lesson will be on the constitutional due process of law concepts. I practiced law for about 30 years, but that doesn't mean that everybody seems to understand the idea that due process of law includes, among many things, notice and an opportunity to be heard, and the creation of a record of the proceedings, so that if you don't like the outcome, then you have the ability to appeal to a higher judicial authority. That seems to be a concept sorely lacking in the education world, maybe non-existent. The second lesson, and I envision that these might each take about 15 minutes, is just what is the Americans with Disabilities job accommodation? What is that all about? And just briefly, the concept is that if a person has some disability that otherwise would allow them, if there were some treatment or accommodation required, would allow them to perform the job and to do their best work. So the idea is that if a person with a disability, and that could be a very wide-ranging topic, but if they have a disability, is there a reasonable accommodation that could be made to allow them to do their essential duties and in fact do their very best work? So that would be lesson 2. Lesson 3 would be what are the legally binding federal, state, and court decisions that deal with the Americans with Disabilities Act. The American Disabilities Act, the ADA, has really only been in existence in its current form since the early 1990s. Now that might seem like, hey, 25 years, what the heck, that's plenty of time to have perfected this whole thing. But the truth is, in law, these concepts sometimes take hundreds of years, and the usual guiding principles in a common law country like the United States is that court decisions interpret the legislative intent and create binding legal precedents based upon certain concepts. And I have found that this is not something that necessarily all or even any college administrators seem to have a concept in. And maybe I shouldn't be so harsh. They didn't train in the law, and they, like many people, don't like regulations that rein in their abuses. So I try to give them the benefit of the doubt, but what I really want to give them is training so that they are not left in the dark about their duties and obligations under the Constitution and under civil rights laws. The fourth lesson would be, really probably to most people, kind of a mundane concept of how you present evidence and how the burden of proof shifts. The really neat thing about the ADA is that once an applicant has presented a request and it is a reasonable request, in other words, it's a request that can, is feasible. Once that's happened, it is not the applicant's duty, the employee's duty, to convince beyond a reasonable doubt, or even by a preponderance of the evidence standard, that they should be granted that. Once they present that request, then it is the burden that then flows to the employer to show that it isn't a reasonable request. They have to show by at least a preponderance of the evidence, more probably that it is or that it isn't. That's sort of the standard in civil law. And they have to prove that it is not a reasonable request, which is a huge distinction between placing all the burden on the disabled person. So that's the fourth lesson. Now, the objectives here is to demonstrate an understanding that college is not immune from compliance with federal and state case law and the interpretation of the courts of the Americans with Disabilities Act. There are people I have run into who seem to think that that old English common law, the king can do no wrong concept, is still present in the United States. And of course, it's only present in a very, very limited fashion. The king can do wrong, and the government doesn't have immunity from all of their wrongful acts. Sometimes people in ivory towers and ivy-covered ivory towers may think that they are immune from certain federal and state laws. Well, of course they're not, and that would be one of the major objectives. The other, second major objective is to identify the concept of this legal burden that I've talked about and how it shifts to the college or the employer. Once a reasonable request has been presented, and it's their duty then to show that it's an unreasonable duty, and it's not the duty of the employee to bring in the best medical and rehabilitation specialists in the world to show that it's reasonable. It's the reverse of that. And then the final thing is that, the final objective is that colleges should be required to exercise an affirmative duty to collaborate in the development of the accommodation. It is the college, once they see and have received a request and it has met the standard of reasonableness, it is their job to work with the employee. So those are the three major objectives of this training. I would envision that there would be tutorials, about 15 minutes each, on these 4 lessons, and that throughout we would have some sort of an assessment that would be a cumulative assessment of the 4 lessons. And I think that it could be gamified by having the answers to questions be rewarded instead of points, but in dollars. And the dollars would be dollars to be awarded to an employee requesting, or a potential employee requesting an accommodation, so that you could, if somebody completely blew it off and did the same things they're doing before the training, then they could see that they would have a score in which they might owe $1 million to $1.5 million to the plaintiff who sues them. Now, there are several cases, state and Supreme Court of the United States cases that establish awards of that nature. So that's my envisionment about how the assessment might work. Uh, Specifically, you'd have some matching questions, multiple choice, true and false, and you'd result at the end with maybe no liability, no financial liability, or maybe multiple, 6, 7-digit monetary awards against the college or university for violating the civil rights and constitutional rights of the plaintiffs.